Hey folks, I'm Denise Howell, and you're about to listen to This Week in Law, where Matt Curtis and Stefan Schweida and I are all very jealous of our guest, Jordan Walbesser, who is in-house counsel with Mattel, aka he's a toy lawyer, folks. We're going to talk about privacy. We're going to talk about the Senate looking at potential federal privacy legislation. We'll talk about the Internet of Things and its data concerns. We'll talk about whether copyright should play a role in regulating use and ownership of data. We'll talk about biometrics at the mall and at the airport. We'll talk about drones potentially getting shot out of the sky. And of course, we'll talk about cows with Wi-Fi. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Stefan Schweida. Episode 436, recorded September 28th, 2018. Cow pie Wi-Fi. Hi, folks, it's Denise Howell, and you're joining us for This Week in Law. We're really excited that you're here with us this week. We have a fantastic guest joining us this week on the show. Jordan Walbesser is here. He is in-house counsel at Mattel, a.k.a. a toy lawyer. Hello, Jordan. Great to have you on.
Thanks for having me.
In addition to being a toy lawyer, Jordan is also a longtime geek. He was a computer engineering major undergrad, and his law degree is in IP. I thought that was interesting, Jordan. I've never seen a law degree in a specific area before. That's pretty cool that you were able to do that.
Yeah. It's one of the nice things that our law school had was you could have concentrations. So your second and third year, you get to pick the classes that you thought were relevant or you thought were interesting. And I had a desire for intellectual property. So, that's what I did.
Right. Don't we all have a desire for intellectual property? You're also a patent lawyer. Very cool. You're our only patent lawyer on the show today. So patent-related things we can get into, and we will later on the show. My two wonderful co-hosts are here with us as well. Stefan Schweida is here. Hi, Stefan.
Hi, Denise. Hi, Jordan. Excited to be on the show with a toy lawyer today. I've never used that phrase, but it rolls right off the tongue. So
it does. I like it. I think your business card must be really fun if you're a toy lawyer.
Oh, absolutely. I've been trying to get the folks in the lab to come up with something really interesting. So, they're busy making toys, so they tell me. But I'm still holding out hope.
Yeah, I am too. You'll have to show us when it manifests itself. Maybe it could be an actual toy that you just give out, and it's got your contact information embedded in it somehow. I like this idea.
There's a great idea. Yeah.
Yes. Stefan is a lawyer at Dorsey & Whitney in Seattle, Washington. And also here is my other co-host, Matt Curtis, co-founder of Pareto Life Sciences. Hi, Matt.
Hi, how's it going? Great to be on here. And if I would have known that toy lawyer was a job as a child, it definitely would have been on the top of my list.
I know. I think we all would be toy lawyers or space lawyers, right? We love our space lawyers too.
I think I would choose toy lawyer over space lawyer, which is maybe sad.
I've got it. Space toy lawyer.
There you go.
All right. Well, from the ridiculous to the sublime, we're going to talk about some privacy law. I don't know if anyone's been paying attention this week, but it's been a pretty big week in the town of Washington, D.C. Yesterday was a pretty big day. The day before yesterday was also a big day on the privacy front. That is the day that the Senate Commerce Committee had a hearing on where a bunch of tech and telecommunications executives attended, but zero consumer privacy advocates attended, strangely enough, all on the question of whether the federal government should enact a federal privacy law, a data privacy law, that would, if such a thing were to happen, among other things, aside from providing some uniform standards throughout the country, it would take things like California's privacy law that just got passed this summer and preempt it, because that's how that works. When the states enact laws that the federal government decides to wade into the area and enact its own law, it's the federal law that preempts and applies. And I'm oversimplifying that, but that's the general rule. So there was this hearing this week. We know generally about the hearing. It was not a public hearing, so I think we've got reporting from people who were there. And they discussed the kinds of things you would expect them to discuss. Things like what these executives thought the federal government should do, whether they were going to resist having federal law in this area or thought it was a good idea. And it seems like the outcome was they told the senators they thought it was a good idea as long as they could be pretty intimately involved in how such law takes shape, and as long as the requirements on them were reasonable in scope. So, Matt, let's start with you. Were you paying attention to this, and do you have any thoughts on, first of all, the federal government weighing into this area, and secondly, this hearing specifically?
Yeah, so on the hearing specifically, I don't have that much. It was a closed session. I think that what we do know are from the proposals that were drafted by I believe the Trump administration had one, but then also Google and the various companies there had proposals. And I think that this does come out of a legitimate concern that different state laws could create different regulations. California recently passed their own privacy enactment, which is watered down from the European version of the GDPR. But and I think that the concern is that if states get involved in sort of crafting their own privacy regulations, then you're just going to have a mismatch. It's going to be hard to do business, especially for startups. On the other side, though, is that the federal law is just so watered down that it doesn't ensure any privacy rights. And I think that's why it's a valid concern that there's no sort of representatives from an EFF or somebody who's more concerned with privacy than the companies. So I think that's interesting. The second thing I really took note of is that they're trying to pass a law not to have a stable set of rules, but in order to allow the FTC to determine this. The plus and minuses for that, from a company's perspective, is that if the FTC takes control and you have a more government or a pro-business favorable administration, such as the Trump administration, you're probably going to have less privacy restrictions. But if you have a Democratic or someone similar to President Obama, you're going to have much more stringent rules. So I think that there's pluses and minuses to having it federally ruled, and we'll just have to see how it comes out.
Yeah, I think they're a long way from actually enacting anything. This hearing was sort of to continue to inform the senators of the lay of the land and sort of talk through their various options, including whether the FTC should be the sole regulatory body for enforcement of such federal standards of data privacy, or whether we sort of have the opposite of that in the new California law, where not only the state attorney general, but there are private rights of action for breaches of the new requirements. Jordan, any thoughts on this?
I think it's sort of hard to say until we really see what's going to come out of these committees. It's good to have a federal set of rules. I think it's always been difficult when you have multiple states coming up with multiple sets of privacy rules. It's not that they're not well-intentioned, but you end up playing to the lowest common denominator, or whoever has the most stringent rules. So, I think it's a step in the right direction. And I think it's a good point, too, about who is going to dictate these rules? Is this going to be a function of the FTC, or is it going to be something in statute? I think from a business perspective, it's better to have something in statute. Although, I understand from the practice of law, and having statutes that stay timely, especially in the technology space, is very difficult. So, it'll probably be a mixture of those two things, and whether the United States moves to a watered down GDPR regime or adopts something like it fully, I guess time will tell.
Stefan, what do you think about all this?
I kind of echo Matt's statement about there being a sort of an interesting conflict between on the one hand, the justification to have a federal statute here that is a little bit more predictable and lays expectations out more clearly and streamlines the process. On the other hand, on the California side in particular, you could see California being the right state to try to innovate some of these policies, given the concentration of stakeholders there. And if any state's going to do it in a way that's going to be responsive to those needs, it's going to be California. Now, I understand some of the companies based there might disagree, and certainly EFF has articulated some of the reasons why those companies might be uncomfortable with California leading the charge here. So, at this point, all I can say is that the request for comment, as I've looked at it, has laid out some pretty interesting guidelines and concerns that they're trying to balance. And my understanding is one of the things that came out of this process so far is that it's wrong to assume that every major company has the same goals and interests here. They all approach privacy a little bit differently. They all have different business models and business objectives. And that might be one of the reasons why some of the consumer advocacy groups have been left out of the process so far. Because to first order, you need to figure out, what are the major corporate stakeholders bringing to the table, because they're not all on the same page and they don't all have the same goals in mind. So maybe once that part of the process is sorted out, then it makes sense to bring in consumer advocacy groups. And so I don't think it's completely nefarious to have left them out so far.
Yeah, I see what you're saying. Like I said, I don't think they're close to getting around to even a draft bill at this point, rather than even enacting something. So I do think that they've got plenty of opportunity to hear from everyone who should be heard from, and hopefully they will take those opportunities and make sure the bill is well advised. Yeah, the California bill, while I think largely heralded by privacy advocates as a good thing, it's not without its problems. And I really encourage people to read Professor Eric Goldman's posts about this, where he drills deep on sort of the scope, particularly of the bill, and the fact that it's sweeping in mom and pop businesses who really aren't the problem and are going to have to do some compliance things that are going to make it really cost prohibitive and difficult. So there are definitely increments of improvement that could be made to the California bill and to any federal bill that gets enacted that might potentially replace it someday. Any final thoughts on federal data privacy before we move on to a topic that such a law might apply to? Matt?
Yeah, this is just really, really hard, a really hard topic to regulate. So you have what amounts to an incredibly valuable set of resources to any company, whether you're a small startup or a Google, that varies across different industries in terms of its value. But there's no question that user data is valuable and going to continue to be valuable. And then you have individuals who are using these services who mostly don't look at their terms of services, that don't really have an option otherwise to use them, at least conceivably, or a good alternative for a lot of these companies. And so weighing and balancing those two broadly different propositions is nuanced and difficult. And this is going to be something that continues throughout our lifetime.
Very true. Stefan?
The value of the data is something that I've found interesting for a while, because there are a few analogs outside of this context that I can think of where just by living and going through your day, you're creating something of value that you have no ownership stake in, but creates value for somebody else. I think that when it's gathered and aggregated and processed, obviously. So there's just sort of an interesting conceptual leap that I think the average person hasn't quite made yet in thinking about how their daily activity is creating value for people, and what sort of standard common law concepts of ownership that might implicate. And I just think it's a conceptually very interesting field, even if you separate it out from privacy and just kind of go back to the very basic questions of, is your data your own property, or does it belong to somebody else who kind of takes it from you and does something with it? I think those are some really interesting, hard questions that aren't yet reflected in the statutes or the regulations, and it'll be interesting to see where the policy goes.
Yeah, and that's been true for some time, and I think that we are probably closing in on the time when those questions have to be answered. Jordan, any final thoughts on this?
Yeah, I think, and you mentioned this, Denise, where you have large companies and small companies that are handling private data. When privacy and security really go hand in hand. So although the larger companies may present more of a target or a surface of attack, so to speak, it is the mid and the smaller companies, the mom and pops, that will eventually be targets, if they aren't already targets, of some nefarious activity one way or the other. So, for better or for worse, those mid-sized, small companies are going to need to have good data security and good privacy controls as well. We can't just expect the big companies to handle all of that, even though they may have more data.
Yeah, that's a really good point. That you have to, they could be the weakest link in the security chain, and that needs to be taken into account. Okay, so let's think about a way and with a subject matter that may be something that the lawmakers want to think about as they're coming up with such laws. Listener Alec wrote in and gave us some CanCon. This is something Stefan told me is an actual term that used in Canada, where Canadian content has to be inserted into what radio programming was it, Stefan?
Yeah, that's right. So the mandated inclusion of Canadian artists in the sort of radio stream is referred to as CanCon. Yeah.
Right. So we have Alec wrote in about this episode in Canada, and that he also pointed out a BuzzFeed piece from August that emphasizes that it is not just Canada that needs to be worried about this issue. It's the United States, and I presume everywhere. But sticking in Canada for a moment, there was a bit of a scandal up there when it turned out that the owners of 23 malls across the country of Canada, they're called Cadillac Fairview, is the real estate company that owns and operates these malls, are being investigated by the Privacy Office of Canada. Canada, against the backdrop of our previous topic there, has a federal privacy law. It is called the Personal Information Protection and Electronic Documents Act. It is Canada's federal private sector privacy law. And the governing body that enforces that law is now looking into these malls because they're using facial recognition software and cameras in the mall directories. So when you walk up to you're trying to figure out where you are, what stores are where, et cetera, to track shoppers' ages and genders without telling them. There's no mention of this in the signage outside the mall or inside the mall. There is a notice on the premises that the premises are subject to video recording for safety and security. So clearly this, well, maybe not clearly, but it seems to me that this facial recognition technology was added in sort of after the fact, and they either didn't think about the fact that maybe another notice would be necessary or a good idea. And that their video notice probably swept it all in. So there's no outcome here yet. It's being investigated to see if this has violated the Canadian federal law that applies. The Office of the Privacy Commissioner of Canada is looking into it. But I think people were just surprised that they were being tracked in this way. And the real estate company that owns all these malls acknowledged that it was using this facial recognition software and the cameras in the mall directories to track shoppers' ages and genders without telling them. Presumably, some of that is probably for security purposes, but some of it might be more on, as we were talking about the value of the data, who's shopping where and can we target them? And so it's a pretty interesting development. Now, the thing that makes it interesting for the US and elsewhere is that Canada is by no means alone. And there is a company called Face First that is selling facial recognition software that is designed for the retail arena, and they're selling it in the United States and elsewhere. And in fact, Target has tested technology like this. Walmart has tested technology like this. And if you look at the BuzzFeed piece, the emphasis is really on cutting down on shoplifting. They are comparing shoppers' faces to people in known databases of known shoplifters and trying to determine, if you look at the BuzzFeed piece, there is a little Face First clip of how the software works, and it'll recognize a face and it'll give you a little box that if you're the retailer that says, observe this person or take other action. So the point here, tying in with the federal government wanting to have federal standards for how people's data are used, is that as of right now, there's nothing to stop this in the United States in any event, except in the state of Illinois, where it's been illegal to collect biometric data without written consent since 2008. So everywhere but Illinois, every retail outlet but Illinois who wanted to do this could. In fact, Illinois has been criticized by some. And again, in this BuzzFeed piece, there's a person who calls Illinois an innovative desert because of the fact that people aren't able to use these kinds of technologies without written consent there. So what does everybody think about all this, Jordan?
A desert of innovation. That's probably a bit of an overstatement. It's interesting, and I think it does harken back to the need on a national level to think about what kind of privacy laws and what kind of privacy rights we should have. I can't speak to Canadian law. I'm just not aware of it, but it's interesting when you think about this technology and how, in some sense, it automates what a person can do. There's no reason that a mall couldn't have some employee at each entrance and track and make a note of who's coming in and going, and that doesn't seem to be as offensive to us as a computer doing it automatically. And I don't know if that's because of the automated nature, the computerized nature of it, or perhaps the fear and promise that you'd be able to link that information to 100 or 1,000 other databases and get a full profile on someone, something that an employee just couldn't do. So, this is the brave new world. These technologies are fairly inexpensive. And we're going to start to see more and more questions about when it is ethical to use these without notice.
Absolutely, and it's. I think it sort of bridges that divide between the ownership issue and the privacy issue. What interest do people have in preventing themselves from being photographed in public and then checked later against a database of, any number of databases, a database of known tennis shoe fans, or a database of known shoplifters. Is it their data? Is it their name, image, and likeness? We, of course, have right of publicity laws that prevent people's name, image, and likeness from being used. Not every state has these laws, but many do, used for commercial purposes without their consent. So that could be implicated. What do you think, Stefan?
I think the thing that all companies who do this understand is that if you improve someone's experience in any sort of meaningful way, they're going to ignore the ethical questions, I think, or at least not keep them top of mind. And so if you go to a mall and someone's tracking your face and you don't really know why they're doing it, you might feel uncomfortable. If you go into a mall and they track you and all of a sudden a customer service representative of some sort walks up to you and solves some problem for you, brings you an item that you may have been shopping for because they've sort of cross-referenced the data with your home device that kind of populates some blockchain with information about what your toothpaste status is, and you walk into a pharmacy and all of a sudden someone hands you the tube of toothpaste that you came to buy, that's going to delight people in a way that initially will be uncomfortable but eventually be time saving. And I think any of the ethical problems will kind of recede into the background. And so that's obviously not going to be true of everybody, but if anything we've learned over the past several years is you give people an opportunity to question the ethics of something, and it's academic and it's legal and it's difficult to follow. You give somebody a solution to a problem and they're happy, and maybe they don't think about what's behind it. So it wouldn't surprise me if the bet some of these companies are making was, yeah, this is thorny, this is uncomfortable, but ultimately the market's going to prevail here. And so we're willing to risk the legal liability in the interim to have the opportunity to be market leaders in this area. And any discussion of the ethics and any discussion of the legal framework around it has to be clear-eyed about that ultimately, if people are happy with the experience, that's going to trump any kind of academic discussion of, should we really be doing this? Yeah,
that's a very pragmatic and good point. Jordan, what do you think?
Okay. No, it reminds me a while back, there was a story that Target was sending out personalized ads, personalized coupons based on your browsing data and some of the purchases that you've made. And it was able to identify that a woman was pregnant before she had told her family or her parents. And then they received this this mailer at home, and it came as a surprise to everybody because she was trying to keep it a secret. And here it was, buy baby gear, buy this, buy that, buy diapers. So there's practical limits to that too. It would certainly be nice to have someone come up to me in a store and say, here's all the things that we think you want. I mean, there's convenience to that. But there's also some things that I may not want to have someone come up to me and say, are you feeling better? I heard you were sick, or, boy, is that toe fungus cleared up yet? So there's going to be, there's certain things that we might not want to have happen. And part of that, I think, is just pure common sense, right?
Right.
But there's going to be unforeseen consequences no matter what with this type of technology. So, we'll see. Hopefully cooler heads will prevail, and there's certainly benefits to it. But there's also risks too.
Yeah, I think you guys have definitely identified an area that lawmakers should be thinking about, the difference between toe fungus and toothpaste or pregnancy and toothpaste. Because once you start getting into more personal, more medical kinds of concerns and using people's data that way, I can tell you as someone now, it's been, a decade and a half since I was pregnant. But even then, the amount of thirst for you to come in and buy those baby products was just like frightening. And I'm sure it's worse now. Matt, what do you think?
So I think that I think that you guys did a great job of covering the points, but in terms of in the fact pattern of the Canadian shopping mall, the restrictions on stealing are probably aided. If you look at using biometrics to restrict stealing, giving notice and putting on a camera that you're using biometrics and you're tracking facial image recognition probably helps in that goal. So I would imagine that in terms of a policy standpoint of stores putting this in, they'd probably be willing to do that. But I ultimately agree with Stefan that the value here in biometrics is far greater on the helping people to buy more than on restricting people from stealing. Stealing is, I think that it accounts for 1 to 3% of retail activity, and so you think about the benefits that it can give to a company, and there's far more than 1 or 3%. You look at something like Amazon Go, you're using biometrics to, or conceivably you'd be using biometrics to track what you're buying in order to get rid of your your cashiers and improve experience. So I think that there's, when we're looking at what the policy is in here, I think it's going to be drowned by all the benefits that come from a consumer experience in a retail shopping environment. And I think that retailers are going to, they're competing with an onslaught of buying online, and they're going to seek to use every advantage that they can.
Right. What you guys have been describing is something like the experience Amazon and now many, many others, but Amazon sort of pioneered the experience of, if you like this, you're going to like this, and trying to use the data they had about you to personalize your shopping experience, but doing that in the real world to compete with that online shopping experience. I've been thinking as we've been having this discussion, is any of this really relevant? Because do people really walk into malls and stores anymore? And I guess they do, sufficiently enough that that sector of the economy has not completely vanished from our ken. The other thing that occurs to me as we talk through this is we've talked about on the show before and had experts on the show before discussing how these facial recognition technologies are far from perfected. And when it's for a law enforcement-esque kind of purpose is when it starts to get scary from a due process kind of standpoint. And if people are going to be, harassed because they were a false positive for someone who's a known shoplifter, that's not going to enhance their shopping experience one little bit. Anyone have any further thoughts about the sort of creepy profiling aspect of this, Jordan?
Machine learning and artificial intelligence is kind of a hobby and an interest of mine. So recently there was a lot of talk. I think Amazon had a sort of an open source machine learning and identification algorithm that they were using, and the accuracy wasn't fantastic. So if you're going to, it's one thing to try to identify gender, age, height, things like that, but to actually point it down to a specific person, there's a degree of certainty that is required that I don't think our automated systems can really live up to, at least not with differences in lighting and angle. It's getting better and better, but we're not there yet. So when it comes to due process issues or criminal issues, I think we can't rely yet on these types of technologies, nor should we expect them to sort of maintain that or to identify potential issues. It's too far right now. We'll get there someday, but it's just not right now.
Right. I'm not familiar enough with how this one retail targeted app works, the details of it face first. But you could see, the example that is given on their website is showing that retailers should observe a particular person based on the match. You could definitely see that being pushed to call the police immediately if you see this person. And that could be, here's another one, violent offender, armed and dangerous, LAPD most wanted, call 911. Yeah. So, and that's from Face First. So they're definitely purporting to be able to tell someone to call the police. And you could see where that could quickly get dicey if the software is not working as it should. Stefan, any thoughts?
I think this goes back to there's an obvious glaring due process question that is triggered whenever this topic comes up, and I think it's important. I also think that so much will depend on how the issue is introduced into public discourse. And the reason for that is if you ask anybody about the due process issue and you frame it from a perspective of wanting them to identify it, I think most people can intuitively get there pretty quickly. But in their lived experience of going out at night or, going to any neighborhood where they're not comfortable, I think most people would rather have a sense of security and will sort of accept a certain amount of compromise on privacy issues to get that security. And I think the people making this technology know that and understand it and will exploit that delta between, academic discussions of due process and actual experiences that people have and want to have when they're out shopping or just going about their daily lives. And I'm not taking a moral or ethical or legal position on this. I just think as a practical matter, it's very easy to identify due process issues and to be concerned about them, while at the same time making decisions that would appear hypocritical in light of those concerns. And I'm not sure I've ever heard anybody convincingly reconcile the academic questions and sort of the legal constitutional questions around due process with the day-to-day experience of most people going about their lives. And, that at some point you need to tell somebody your concerns, your prejudices don't matter as much as other people's rights. And to make that a convincing political statement, a hill that someone's going to die on in writing this legislation seems improbable to me. And so that's why it may sound cynical, but I have a tendency to believe that a certain amount of technological determinism is going to be the driver here as long as it's playing to people's prejudices and sense of convenience and safety. And so if someone's brave enough to stand up and say, my political mission is going to be to put a stop to this because I think the due process issues are more important than the consumer demand, then we'll see some change. Until then, I think whatever people can dream up and implement that makes things more convenient and more commercially viable, that's going to be what controls the situation.
Right. And you mentioned safety too. And I think that's going to play into it too, that a lot of people would look at this and say, hey, if it's got a chance of catching this guy who's armed and dangerous and on the LAPD most wanted list, oops, sorry if we inconvenienced you that you're not that guy. But, and ruined your day and possibly more than your day. But we want to catch that guy. So it's definitely a tough issue. Matt?
Yeah, especially for like an airport or a stadium or something like that. Those soft targets from a counterterrorism perspective are probably going to be the first one that these are widely used in, and probably are already being used in. But in terms of like a baseline of due process, though, you have to realize that your alternative to computer vision or, with the Amazon instance, your alternative is a witness statement, which is like very unreliable, yet we use it in our courts every day. So I think that what's going to be hard from a due process standard is that you're going to have to show that it was not only like, we want it to be perfect, but like 65 or 70% is probably better than the average witness statement. And so that's why I think that it's going to be really difficult from that standpoint. And like the two things we really want in this are counterproductive to each other. We want that they're accurate enough to say reliable that it was you, but we also don't want to be watched 100% of the time in our activities. And I think that those are like fundamental conflicts in, from a privacy perspective about what we want with biometrics or facial recognition. Is that we want them to be right in the court of law, but I don't really think that everyone wants to be watched all the time, at least not personally. Maybe we want other people watched, but not us.
Have we crossed that Rubicon already, however?
That we're being watched all the time?
Yeah.
Yeah, I think that the concern though is that like, yes, we've had cameras everywhere, since we had ATMs and since we've had, your local convenience store has them. But there was no ability to aggregate the data really. These were all decentralized systems that weren't working together to track who you were. So you could walk into your gas station and that data would not be transferred over to, your other activities in your life. I think that that's the concern, is that there's continuous tracking.
Yep, definitely. All right. So let's move on to things that, this is very much in line with what we're already talking about. The Apple Watch Series 4 has a great feature where if you fall down and you stay down and you seem to not be responding to the loud, annoying things the watch is trying to do to ask you if you're okay, it's going to call 911 to help you. And this, facially seems to be a great thing for people who may need this help. However, as Elizabeth Joe, who is a law professor at UC Davis, pointed out, there is an exception to the Fourth Amendment. It's called the community caretaking exception, which allows law enforcement to enter a home without a warrant. And I don't know how that's triggered, if it's when someone in the home voluntarily calls for emergency services, or when a watch. I guess by definition, I would think this is how this would play out. If you're wearing a watch that will call 911 for you, that's going to be interpreted as voluntarily calling 911. So they can enter your home without a warrant. And as Professor Joe points out, the plain view doctrine means that if there's evidence of a crime in your house, they can seize it and prosecute you. So, or someone else. So this is something that probably did not register too much with the folks at Apple when they came up with this feature of the Apple Watch Series 4. Others have weighed in and said, this is a great service, but maybe just having it set up to call a contact that the user determines as opposed to 911 might be a better call. Of course, when you need 911, you need 911. You don't need any delay in getting them there either. So I suppose it would be ideally best to leave it up to the watch wearer how they want this feature to work. But the default call 911 feature could be problematic from a Fourth Amendment standpoint. What do you think about this, Jordan?
Oh, it's a good question. I think for a technology like this, the benefits are going to outweigh the any risks of the Fourth Amendment. This is such a problem for not just elderly, but any medical emergency. And I think it may be a bridge too far to say that this is automatically going to call the police, and then the police are going to show up at your door and break in and find some contraband or something. I don't know if that's very realistic. It seems to me that the fire department or an EMT or an ambulance would be the one that would be dispatched. But nonetheless, one of the problems here is going to be false alarms. And I don't know much about the technology to know its accuracy, but false positives are going to be a drain on community resources. I suppose you're better safe than sorry, but if there's some sort of error or if the accuracy isn't really what we want it to be, I could see this being a headache for first responders.
Chickenhead 21 in IRC says, I've fallen and I can't hide my stash. Kind of busting up here. Stefan?
This reminds me of the security alarms that a lot of people have that provide a sort of a warning to people that, if you break into this house, there will be a loud sound, and 3 hours later the police might show up. And yes. On the homeowner end, it's like if you don't disable this in the first 30 seconds, you will be fined $100 for wasting the police's time, whether or not they show up. And which is to say, this sounds like a first step in a technology that's going to mature in a while, and it sounds a little bit like a beta test that's being distributed to a lot of people to gather some data and tweak the technology and make it better. And you could see it in its mature form being very useful, and I hope that it saves lives.
Right, you're absolutely right, and you've both pointed out, and Reverb Mike and IRC is pointing out that he says this will crush our 911 system with false alarms, and hopefully it won't be that bad. But the scenario you bring up, Stefan, the city generally can, as you say, reach out and fine you if your alarm's going off too much and pestering them. And I just wonder how how law enforcement would deal with an overabundance of watch-related notifications. Matt, any thoughts?
Yeah, I mean, in terms of like the worry of overuse of police resources. There's plenty of analogs on the market right now. Whether it's a beeper that elderly people wear, specifically when they're living remotely and not within homes. I think that this market's just going to grow. I mean, we have an abundance of people entering retirement and who want to stay in their homes, and so some sort of technology is going to be used for this to automate this process. In terms of the Fourth Amendment concern, I think that what Stefan brought up in the last conversation was when the benefit outweighs the cost, you're going to kind of eye roll at the academic piece, and that's what I did when I read this. I said, most people aren't committing crimes, and so their concern isn't going to be, you should stop me from using this technology, because someone else who is committing a crime would be penalized if they use this technology, which they can choose not to use. So I think that that's I think that that's the overlay of these two conversations. I think that feeling is probably going to be the one that wins out.
All right. Well, I think I've fallen and I can't hide my stash. The first MCLE passphrase for this episode of This Week in Law. We put these phrases into the show in case you are watching or listening, or both, hopefully both. If you're watching, you're also listening, for professional credit in your field. I would think that just doing the visual of this show would be really difficult. Anyway, we do support you in your endeavors. If you're a lawyer or other professional, if you want to apply to get professional credit, have at it. We have a list of resources at twit.to/MCLE related to lawyers in the United States. You may have a jurisdiction where we've looked at, hey, there's a forum. You can use that to ask for credit. So head on over there and check it out if that's something of interest to you. We put these phrases in case you need to validate for your oversight body that you actually participated with us here on the show today. So we'll put another phrase in before we go ahead and wrap things up. There was one thing before we leave this privacy topic. Virgil made a good point when we were talking about federal proposed privacy legislation. Brought up the fact that the FCC had put some restrictions on internet service providers that related to what they could do with data, and those restrictions were rolled back. But I bring it up to say that yes, that was some measure of federal control on data in one arena. But I think that what the lawmakers are contemplating now, if they don't just punt it to the FTC, would be something statutory that would apply not just to one area of business, but potentially to all. Anyone want to comment on that part before we move on and talk about the Internet of Things? Jordan?
Nothing in particular. I think it's a tricky topic, and I hope Congress can do a good job. Maybe I'm laughing. Maybe that's not fair to them, but it's going to be difficult going forward. So, FTC or statute, it's going to take a lot of thought and experts from across the board to hash this out.
Okay, Stefan, any thoughts on the fact that the FCC had tried to put some restrictions, at least on ISPs, as to what they could do with the data they collect about their users?
This is an area I got to kind of tread lightly on. I think, I hope they keep having public hearings and inviting people to speak on what the concerns are and come up with something that everyone can get behind. Which
definitely.
That's me treading lightly.
All right. When you start to sound like an elephant, we'll let you know. Matt?
I don't have anything specifically valuable to add here. I would say that the original FCC plan was an opt-out, which allowed companies to set up payment. You could essentially have two tiers of payment for someone who allowed you to sell their data and someone who didn't. I know that some advocacy groups, think that that's not enough. I tend to think that that's the prudent position, that if I want to sell my data, I can. So that's, where I would like to see it come down. But I think it's going to be a long way before we actually see what comes down.
Okay, let's move on and talk about some privacy and other concerns related to the Internet of Things. So before we get into this discussion, Jordan, we will definitely let you know if you're sounding like an elephant here. We are very cognizant of the fact that you are here in your individual capacity and not in any sort of official Mattel-oriented kind of way, and that you have a client that you represent, which is a large international toy company called Mattel, and that it may be problematic for you to discuss certain things that relate directly to your work for that client. So knowing that, we're thrilled that you're here, and we're thrilled that you can weigh in your individual capacity as we talk through these things. But I guess the reason I was interested to think about Internet of Things concerns with you is because of your unique role with this client. So obviously, toy companies and others are on sort of the forefront of coming up with devices that are interactive and are gathering data and are internet connected. And so I'm sure these are things that cross your mind personally. So one of the pieces we have in our rundown today is from TechCrunch. It's mentioning a study where in the UK, they are considering legislation that would require smart home devices such as AI virtual voice assistants, various smart appliances, et cetera, to bake in privacy protections that relate to kids. This is a tougher nut to crack, I think, than the straight toy, right? I mean, it's if you look at one of the things they link to in here is a page from Amazon, which is their disclosure on children's privacy. And they talk about various services that they target to kids and they seem to make it quite clear that that's not everything they do. And I think that there's a discussion to be had around the fact that many of the devices that people are putting in their homes now may capture data about kids, but they're not designed specifically to interact with kids. They are designed to interact with everybody, be it the washing machine or the digital assistant. But with that said, in the UK, this report and the advocates behind this report would like to see something more done to protect children's privacy and navigate a confusing array of terms and conditions than the GDPR, for example, is able to do. So, Jordan, what do you make of this?
Yeah, boy, yeah, I have a lot to say on this topic. Privacy rights and children's privacy rights, especially, is something that I deal with on a day in and day out basis. So obviously, it's something that my client, my employer, takes very seriously, and it's also quite difficult. The connected nature of items, not just toys, but home monitoring systems, the Google, Google's home devices, Amazon's devices, all of these things, collect data directly. And there are things that we have, even the most basic and inexpensive toys now will often have a digital component or an electronic component that captures some sort of information. So when it's toys, I think it's a little bit easier because there's an understanding that the information collected is going to be related to a child, and there are protections up and down the chain from the collection to transmission, which hopefully none is being done in any circumstance. But there are protections there contractually that help protect against that from happening. What this article in TechCrunch is about is a little bit more interesting. This is where you have products that are tracking information, that are collecting information, and it may not be from a particular person, but it can be from an entire family or from friends. So, things like this can sweep up data from a wide variety of sources, not just people that have agreed to it, but people that come over. Your friends that have kids that come over and they talk to your Google Home device. So it's when I read through this one, it was pretty interesting, and we're going to have to figure out, can we teach these devices to differentiate between what involves children and what doesn't? Or is it something where we should be saying, these same type of protections that children have, adults should have as well? Certainly up for academic debate. I'm not sure what the answer is. Frankly, I like the personalized approach that some of these devices have. It can tell me my calendar and what the weather's going to be, and these are things that are fantastic. But going forward, this is a really interesting issue that we'll have to be aware of. I'm not sure if there's going to be any enforcement around this as of yet, because it doesn't seem to be egregious, but it's more incidental collection than anything. So, I'll be following this issue for many years to come, I'm sure.
Yeah, one of the things I thought that was really interesting about this report, which is by Dr. Veronica Barassi of Goldsmiths University in London, is she's coined this term called home life data, which she means the information harvested by smart in-home devices that can end up mixing adult data with kids' information to consider its impact on children's privacy and put this concept at the heart of future debates about children's data protection. So she seems to have her finger squarely on this problem of, it really doesn't matter so much if you're not targeting the kid. If you're targeting the home, then they're going to get swept up, as are, your guests, as you point out, Jordan, and really anything incidentally that happens in that context. So it seems to be shifting the privacy analysis away from, precisely whose data is being collected to where that collection is taking place and whether that zone should be treated differently. What do you think about that shift, Matt?
I think that's going to be a really hard line to draw, because I think that it kind of has to deal with how we think about children. Are they protected primarily by parents, or are they protected primarily by state laws or laws of the state? And I think that historically America, in opposition to Europe, has been much more protective through the parent. A lot of our laws in other areas give protection specifically to parents and not to the state. I'm not sure of England, but I know in Germany the child is thought of as a child of the state, not and they almost have co-parenting rights, much more than the United States. So my suspicion is that we're going to have it's going to be left up to the parents. We've had this with our televisions for years now. Extension of that, we've had kids with phones, which certainly a lot of kids have in their 12 or 13 have phones, and that data is probably more immense than what we're collecting. So I don't think the problem is fundamentally different for that. I think in an extension of that, and my guess is that in the United States we'll leave it unless we can see a clear delineation that it's for the child. As an example, we've been able to create laws for toys and things like that, or when you're signing up for an activity as a child, you're going to be able to create laws around that. But it's going to be really difficult for anybody to create a device that's able to filter out child activity.
Stefan, I guess this plays in with many of the comments you've made on the show today, dealing with, balancing privacy considerations against convenience and a pleasant experience for the person using the device. Do you think that people won't dice things quite as finely as this professor has done, and if their personal assistant is providing them with everything they need, they won't care that in the home, perhaps there should be a heightened privacy protection?
At bottom, as far as I can tell, American parenting boils down to figuring out how to best place your child to thrive under late capitalism. And so any technological advantage that's going to give one kid a leg up is quickly going to be aped by other kids whose parents are equally ambitious and driven to have their child win in the vast game of musical chairs that is life in America. So the odds that well-intentioned, earnest parents who send their kids to special schools where everybody plays outside all day use this kind of technology, pretty slim. Most people who go through public school or through sort of standard education one way or the other, they're going to be incentivized at every corner to sort of adopt whatever's thrown their way, and they're not going to spend their time thinking about the minutia that is reflected in academic papers about privacy. And I say that without sort of any kind of moral or legal conclusions about whether that's right or wrong. I just think as a practical matter, most people who have children are thinking about, brushing their teeth, getting them ready for school in the morning, making sure they've eaten, making sure they don't break any bones, and any kind of complex discussion about, who's listening to them when they speak through their smart speakers, or what kind of data is being gathered and where is it going. I just think is outside of the imagination and concern of most people who are really just trying to push their kids forward to be happy and successful in whatever capacity they can be. So I don't fault anybody for having these discussions. I just think putting the burden or putting the kind of drawing too many inferences from parental behavior under those circumstances, I think wrong, because most people are just not thinking about it and they're just doing whatever they can to push their kids along.
Right. But don't you think most people would hope that their elected representatives would have these issues in mind and might be looking out for their interests?
Well, but I don't know that anybody can really even articulate what a best outcome here is, right? Because I think if in gathering this data, you in some way make the process of parenting simpler in some way, you could flash that in people's faces and convince them that that's what is in their interest. So at the risk of sounding too cynical, I think it's really easy to manipulate how people think their interests are going to be impacted by something. It's you package things in terms of convenience or security or some sort of improved experience one way or the other, and everything else then sort of recedes into the background. So I wouldn't, maybe this makes me sound like I don't have faith in people's ability to discern their own interests. It's not quite that. It's just, I think this is going to be, again, like my other comments today, one of those situations where you've got an academic debate happening in one corner, you have people's lived experience in another, and they clumsily try to relate the two of them. And I hope they do a good job, but I don't have a lot of confidence that both of those elements are going to be in discourse with each other in a fruitful way.
Yeah, I think that's deeply insightful. It's not necessarily cheery, but it's, I think it's dead on. All right, just to lighten things up a little bit, and maybe it's not as light as it starts out to be, or it's as it starts out sounding. Let's talk about the Internet of Cows, shall we? One way in which the Internet of Things is manifesting itself these days is through something called the Moo Monitor, which is a device that connects cows to the internet. This is a chip that gets put on the cow in the cow's skin, I would imagine, and it can monitor things like its health, its movements, its stress levels. It uploads that data to a server. Really, we're not having any discussions about the privacy interests of the cow here. What's done with its data? Who owns its data? Who owns its data is the owner of the cow. And then there is AI software that looks for irregularities in the cow's health and behavior. So this is all, I'm sure, great if you are managing huge herds of cows. And I'm sure it's real interesting if what you have in mind down the road is managing huge herds of people, because I could certainly see various business-related interests, whether it's on the employment side or the insurance side, that would love to be able to monitor people in the way that these cows are being monitored. And so maybe we are beta testing this technology on our bovine friends. I do not know. Certainly this article we have in our discussion points for today, which you can access, by the way, at tagpacker.com/user/thisweekinlaw. We're on episode 436 this week. Nothing in this article suggests that anybody has any designs on chipping humans and using this technology this way. Moo Monitor becoming the monitor of something else. That is just me and my dystopian sci-fi bent. But that being said, what does everyone think of Moo Monitor, Jordan?
Yeah, I'm a bit of an optimist, so I think this type of technology is great. I grew up in the country myself, so farming was and still is a way of life, and herd management and animal management is extremely important. I mean, these cows. They're not just a thing. This isn't a couch or this isn't a car. This is your livelihood. So being able to bring this technology, whether it's the machine learning or Internet of Things, bringing it down into an application that has previously not been serviced or not really been affected by the technology, I think is really great. So there's a lot of benefits to this technology, being able to track and detect and maybe even predict if one of your animals is not feeling well or there is going to be some health issue, I think can be a huge thing. So I think this is great. Can it be used in humans? Sure. I mean, I think it already is to some degree. I mean, I mentioned it earlier with Target tracking your purchases, and we have browser histories, and Amazon knows things that other people bought with this and that, and it's not too it wouldn't be too crazy to say, oh, I'm having a bad day, or oh, we saw that you got a raise, or you seem to be buying a lot of things, would you like this, would you like that? So I mean, I think this type of tracking in the human herd happens all the time, but on a positive note, the technology is fantastic, and I think it can lead to some good things in agriculture.
Well, maybe someone in IRC who Virgil just put in IRC Logan's Bovine Run, which I just love. Anyway, maybe someone will remember the company that has people, gave them the option to voluntarily chip themselves. I think it's just used for things like you don't have to have an employee ID card when you have this. You can just swipe your wrist over a sensor and gain access to wherever you need to in the premises. I'm not sure if it does more than that or not, but I do remember seeing a news story where people were boldly and bravely and proudly showing off the place where they'd been chipped by their employer. So it's not, not happening to humans. It just may not be happening in quite the same way as it's happening to cows. Stefan, cows?
Yeah, I think, from if you could limit the discussion to agriculture, then it would be, ethically unproblematic. I think, of course, as you hinted, that there's a dystopian element here when it jumps from cows to people. It's a little bit like the bird flu. It's like, a bunch of chickens are sick, but then the people start getting sick, and it spreads. And I think that.
But really, Stefan, what would the Bolsheviks have thought about all this?
Well, it's actually it's a great question.
Thank you.
The conclusion in that book that I was reading, and I think it's somewhere here it is, The House of Government. I'm going to plug it because it's just so good. The House of Government by Yuri Shleskin. Fantastic book on Bolshevik history. One of his conclusions is that they were not totalitarian enough because they believed that everything was economic determinism, that you didn't need to worry about family life ultimately. You didn't need to worry about what people were reading at home or how they were structuring their lives, because everything was determined by the economy. And it turned out that was a mistake because people recreated these bourgeois Philistine habits in their home lives and then bled into the public sphere. So I think what the Bolsheviks would have thought about this was, who cares? This is technology. We don't need to worry about how it impacts how people are living their lives, because that's all, it doesn't matter. It's all determined by the economy, and they would have missed an opportunity to be even more totalitarian and thereby preserve their reign over the Soviet Empire. So that's that's the answer to your question on what the Bolsheviks would have thought.
Thank you. Appreciate that.
Yeah, no problem. But I think Bolsheviks and joking aside, I think that at some point we're going to have to make a decision, maybe hopefully before we're forced to make decisions about this. Do we want to be chipped? And if the answer is no, then we should start creating barriers to that now, because if we do this sort of bit by bit, no pun intended, we're going to be chipped before we know it, because it's going to be any objection to being chipped is going to seem purely quixotic and a little bit quirky, because it'll just be that final stage in the process. So if you don't want to be chipped, say so now, because if you just kind of keep making the convenient choice, you will have a chip in you in 10 years. And so that's what I think about the cows.
Got it. Yeah. No, I think once again you're being very pragmatic today, Stefan. Matt, any thoughts?
There's a great song that ties these two together. It's Dana Leon's, and it's Cows with Guns, and it's about the bovine revolution. So I recommend listening to that. And it's a great animated video from like the 80s or 90s. I think that this is great. You think about, there's 93 million cows in the United States, and 83% of the farmers that own those rely on off-farm incomes. And I think that's there's a lot of opportunity there for management, especially because most of these farmers aren't on the premises. So there's been a lot of movement in venture capital to fund these sort of opportunities. There's 3 or 4 companies that have been well funded in the last couple of years that build automated fences, that basically build invisible fences for cows to be able to maximize the growth of the grass. And those are all fascinating and really cool ways to use technology. And there may be actually human benefit for people who live in rural areas, because one of the issues that a lot of these companies have is getting remote internet access to these devices. So the more that the animals and that farming operations are using these, the more that there will be investment in infrastructure for people who live in rural areas to have that.
So instead of flying a blimp over these rural areas with Wi-Fi, you're suggesting creating sort of cow hotspots. They can run around.
I think they should. Drive. You just order. It's sort of like ordering an Uber. You order your cow and they bring you your Wi-Fi. I think it'd be great.
Yeah, we're right back where we started with the carrier pigeons, except now instead of just a little piece of paper, they're carrying a Wi-Fi signal. It's great.
I love it. You have a truly entrepreneurial spirit, Matt. This is once you're done with your current startup, this is clearly your next destination.
I've actually got a patent in the works in a very similar field. So
all right,
we'll disclose that next week.
Okay, so I promised you a second MCLE passphrase for this episode of This Week in Law. It's going to be from Russia with cows. All right, let's talk about a couple of final links we have in our Internet of Things category. One has to do with toys again, and the fact that not legislation about the toys, but the fact that just as a practical matter, when there's something out there that's internet connected and can gather information about you, and it's popular, that there are going to be lookalike devices that are made by off-brand manufacturers that will capitalize on that thing that is popular and in demand, and that maybe those off-brand devices are even more scary than the original thing might be, whether it's scary or not. But that the off-brand ones you may be paying a price for that cheaper device that is not readily discernible. I mean, maybe it is, specifically malicious, or maybe it's just not locked down from a security standpoint. So there is a piece that we linked to with some good tips about that. with wonderful advice like update your Internet of Things or smart devices regularly, check reviews online for the product's name, and see if other consumers have had, or security researchers even worse, have had concerns about that specific product. Various other let's see, if your router has a guest network feature, connect all Internet of Things products to it instead of the main network. Good advice. This creates two networks, both with internet connectivity, but insulated from one another. Beware the cheap, that you may be paying that price that you don't know about. And then finally, consider buying non-smart products unless it's absolutely necessary. With this in mind, there's also a good movement afoot, written up by Carl Bode at Motherboard, about coming up with a safety style ratings system, a food safety style rating system for privacy and security, so that if you were, going to pick out some device and you're looking at competing things and one of them's considerably cheaper than another, you would have some sort of way of looking at it going, well, that gets a D and this one gets an A, or, whatever the ratings, however the rating system works. Something, in other words, another layer that would just supplant or be in addition to the reviews that are already out there, and that would be curated and implemented by an actual consumer watchdog kind of organization. So Jordan, what do you think of that idea and the various advice about using smart devices?
Yeah, I think a good place to start is that article about the Internet of Things concerns for off-brand gadgets is spot on, really. Large companies have the resources, the knowledge, and frankly the finances to make sure that their products are up to snuff when it comes to security. And it's not to say that they're perfect, but there's a lot of effort that goes into that, to making sure that things are up to date and safe. When you have a knockoff brand or an off brand or whatever that may be, a slightly cheaper object, the support, the maintenance for those types of Internet of Things devices may not be there. And if you have encryption that is breakable or whatever it may be, chances are that those cheaper products aren't going to have the support to continue to keep that information secure. So, I think that's a big risk, and it doesn't mean you spend more money and you're safer, but it's something that we have to be very aware of. I like the idea, frankly, of the safety style ratings for privacy and security. And whether or not that is an industry-led effort or something that is governmentally based probably will depend on what we're doing. Obviously, I think there's much more of an interest to make sure that our food supply and pharmaceuticals are graded by the government. But I wouldn't be surprised to start seeing either in the tech side or in the Internet of Things, sort of the heavy industries to come out and say, look, we've gotten together and we have these ratings for these Internet of Things devices, and here's how safe we think the data is. I think it'd be useful, and I think it would help from a sales perspective. It would really help differentiate. Because there would be companies that would focus on security, and there's those that would focus on price, and maybe that's the trade-off that the consumer can make. So I think it's interesting practically how you do it. I'm not sure. You'd have to get a lot of people to agree on what those ratings would be, but frankly, I like the idea. And as far as those tips go, yeah, update devices regularly. That's probably the biggest one, and. Right. It'll be an area that will be, in a lot of flux, I think, in the next few years.
Yeah, I really like this ratings idea because it's a layer of accountability that's less heavy-handed and less fraught than legislation or regulation. But it would be effective if you were, the manufacturer of, say, a internet-connected refrigerator. You would be motivated to put those updates out there and make sure your platform was secure if you knew that, your rating that people were looking at to decide whether to buy your product or the cheaper refrigerator was the right thing to do. So I really like this idea and hope that it gets implemented. Stefan, what do you think?
I can't help but think about the financial crisis 10 years ago, and I think they had a rating system in place there, and all these AAA rated securities turned out not to be.
I think true.
I like the idea in principle, but any system that you put in place, someone's gaming it, and it just. The nice thing about this off-brand versus market leader concept is that off-brand suggests not very deep pockets, and so if something goes wrong, large-scale class action lawsuit isn't necessarily going to be very effective. So in that sense, the big players, not only are they more likely to get it right, but if they do make a mistake, societally there's more recourse there. So any chance I get, I use the phrase off-brand because I think it's a great, just fun phrase to say. And so thank you for the opportunity to say off-brand. But I think that the rating system, it's a really interesting idea. And if it's done properly, it could help. But I don't think it's going to solve everything as we saw 10 years ago.
Right. Well, I mean, haven't we entered the world where everything is off-brand, the long tail world where you can sell your product on Instagram and reach the audience, and you don't have to be on brand these days to be a successful business or to sell your stuff. But that just means that more is available from folks that are not large and well-known or possibly well-funded. Matt, any thoughts?
Yeah, I think that actually that a rating system would probably be more helpful here than in a financial institution, mostly because I would assume that there's some sort of insurance for products liability, and to the extent that in insurance plan, I know we've gotten insurance for privacy, and you go through a 150 long page questionnaire about what are your protocols and procedures, and those kind of force you, because the amount you're paying is based upon what you do and how you secure your data. That's going to affect how you do that. So, to the extent that rating systems help with that, and I think that the grid predicate example is cars. They've gotten safer over the years, and a lot of that has to do with insurance moves and consumers seeing that a Volvo is ultimately always going to be the safest car in the world for some reason, and that that's the way it's. That's how that's been helpful. Where that you can't, because stocks and bonds and other than AIG, which was an insurance for that didn't work out too well, but those are less insured instruments than something like a car or if you have products liability insurance.
Just one quick follow up on that. I guess good point taken. I think some of that becomes a self-fulfilling prophecy, though, right? Like in the case of Volvo, they kind of maintain their safety record because people who are concerned about safety buy Volvos, and being concerned about safety is the first step toward being safe. And so I think there's you don't quite have that same dynamic with something like a toy that's collecting data, because it's not up to you whether that data is collected safely or not. It's up to whoever's controlling the stream of information and gathering it. So there's a little bit of nuance there that I think is important. But now we're so far in the rabbit hole of hypotheticals that I feel like I'm just responding out of some sort of deeply ingrained instinct to try to get the last word on these things. So
right. Well, no, I'm not going to give you the last word, because I'm going to say that your comment about the financial crisis was well taken, but I do think that parents are sufficiently concerned with what's in their house, or just any consumer would be sufficiently concerned with what's in their house, that if they had the choice between an A-rated device for privacy and security or one that wasn't rated at all, the Volvo of washing machines versus not, that would be an important data point in considering the purchase. So
if I could jump in real quick, there's an interesting flip side to all of this when it comes to product design and life cycle. Maintenance and support and security is expensive. So it's one thing when you have cars or sort of other large heavy machinery, a washing machine, a refrigerator, supporting multiple models and figuring out how you're going to end of life those models, because at some point it's not going to be practical to support and continue to update your 1983, or we'll make it more modern. It's not going to be practical to update your 2018 refrigerator when it's 2042. So we're going to have to figure out some sort of end of life policy where that makes sense both for the consumer and the company. Otherwise, the cost for maintenance and the cost for new products is going to skyrocket because those things will have to be built in. So it's there's that side of it too. You can't keep these things supported forever.
Yeah, excellent point. All right, let us do our final bit of CanCon for the show and talk about copyright. We've been talking a lot about data today, and there's this one piece that caught my eye in the Digital Journal that highlights a research paper by a Canadian researcher named Teresa Scaza. She's a fellow with CIGI's International Law Research Program, and she's considering data ownership. Which is something we touched on earlier. Is it property? Is there some other basis, privacy right for ownership? And one of the things she considers here is the copyright side. And she says how the ownership of data is often based in copyright law, or alternatively protected as confidential information. And then in Europe, you've got the GDPR. And she points out that copyright protection requires a human author, and works that are created by automated processes in which a human author is lacking might not be subject to copyright protection. So if we're talking about the output of AI, for example, this is why we keep doing animal selfies of the week and talking about AI, is because it becomes questionable as to whether a copyright applies, or if it does, who owns that copyright. So this is kind of, an esoteric issue to throw in, but it relates to what we've been talking about today. So I'll just toss it out there and take everybody's temperature on what you think the best rubric, I guess, is. Let's take it as a given that data is valuable. I think it's in this interview with Dr. Scaza, she says that she mentions that it's been referred to as the new oil of the economy, although unlike oil, it is an infinitely renewable resource. So it's valuable. People feel like they have a possessory ownership over their data. How should that be effectuated from a law and policy standpoint, do you think, Jordan?
Boy, yeah, I have to go first. I think no, honestly, I think copyright isn't a good fit, frankly.
Mm-hmm.
Copyright, if we take the classical approach, is related to creative expression. And data isn't creative, it's facts. And therefore, I think, I can take the very easy segment and push that out the window. For confidential information, that's probably, especially in the terms of what this article is talking about, it makes more sense than for it to fall under that type of protective regime. So, again, it harkens back to privacy rights for the individuals that are supplying that data. If it's data that doesn't relate to an individual, I think it's just data. It's as protected, maybe under trade secret, or if you make it public. I don't think there's any protection there. It's just facts. And from what I've seen with artificial intelligence and machine learning, I don't know if we're to the point where we need to have a serious discussion about whether a computer can do something that's creative. They can follow instructions really well. In fact, that's all they do. So I don't know if we're at that precipice yet, where we have to decide if if there's a work of authorship that's being created, and even if there is, I'd say that it's probably the programmer that would be the author, if there even is one.
Okay, Matt, any thoughts?
Yeah, I think that all the privacy concerns are real, and we've been talking about those for a while. It just you don't have a copyright to like a subset of data. How you arrange them, you can get a copyright in, but not the data itself. I think the position that if I create the program, if I create a system that writes another system, the underlying copyright is the person who wrote that. I don't know if there's any judicial opinions yet to have stated that. I know that there is software that writes other software, so I would assume that there's at least the opportunity to do that. Now, it's not the mind-blowing things that we think it is, but there's AI that writes music that sounds awesome. We've had some on the show before. I can't recall though. I certainly haven't seen any opinions that directly deal with this.
Nope, me neither, not yet. Stefan, any thoughts?
I'll kind of present a metaphor, and maybe that'll get you to how I think about this. So imagine like an alpine lake that's perfectly still. That's the platform that a company has created. And if you're the only person on the shores of that lake and you step in it and there's some ripples that go out, those ripples are your data. And, somebody looking at the ripples can maybe figure out where you're standing and sort of know something about you as a result of that. If there's 100 people on the shore and they're all splashing around, there's many ripples, and that's kind of this aggregated data, and it's less informative of you as an individual because in the aggregate, it's harder to figure out who the individual is. Who made that particular ripple, even though those ripples may still have some value in the aggregate to figuring out how many people are on the shore. So I think it's an interesting problem because it's not inherent to any human being, so it's not like their DNA. It's just the ripples of their use of something that someone else has created, and it has value. And so I can totally understand the privacy implications and the concerns about your own behavior creating value for somebody else in an uncompensated way. But I just don't think we're at a point yet where we can use copyright law to, with sufficient granularity, account for that simple distinction between, a use that creates data that says something particular about a person using it versus, the aggregate sum of all the different people using a product and creating data that gets put together, has some value for the company, but doesn't quite have the same privacy implications as a single use might. And so copyright law in particular seems like a really weird fit to kind of resolve any of those issues. And I'm not sure that any existing IP framework is quite the right one to use to think about there. I think it has to proceed from policy, and the policy questions are privacy is one of them, ownership's another, and ultimately, going back to this pragmatic theme, if you want innovation to kind of propel forward, you're going to have to give up some control over this, and it's just a question of how much insight do you have into that process, and so that to me seems like a much more fruitful lens to approach this, sort of from policy rather than trying to shoehorn it into an existing IP framework, but. I agree with you, and maybe it's time for lawmakers to start thinking about data as its own thing and not something that should be shoehorned into something else, and it should have its own law and policy around it that is tailored to data. So let's alert the Senate Commerce Committee that we've solved the problem for them. Okay, so let's move on. We've got a patent lawyer on the show. Let's talk about patents real quick. I put this in, Jordan, because I spotted a while ago you had tweeted about blockchain patents. It's something we've, mentioned on the show before, that people are starting to patent their blockchain-related creations.
and really don't have much more to say about that except that it's starting to happen. And I guess for making it topical for this week, one such entity that is patenting its blockchain-related stuff is Walmart, and Walmart this week is in the news for telling its various suppliers of lettuces and greenery that they need to be using the blockchain so that their shipments can be readily tracked and if necessary, shut down if there's something like an E. coli outbreak. So just wanted to toss all that to you, Jordan, and see what you think is up with blockchain patents and Walmart in particular.
Yeah, no, good questions. I think blockchain is going to be really interesting at the Patent Office. We're going to see probably hundreds of blockchain applications and patents as we go forward, maybe even more. What's interesting about it is a few things. One, we have this idea of whether or not is this an abstract idea, the idea of blockchain, and probably not. I think it's such a specific implementation that you could probably get around, and this is patent lingo, but you could probably get around the 101, Section 101 of the Patent Act, any issues relating to that and some of the cases that have come down defining what an abstract idea is. But because of the public nature, both of the inception of blockchain, but also the implementation of blockchain, I think we're going to see, maybe more so than in any other area, a difficulty in getting blockchain patents just because there is so much prior art. So we have white papers, we have open source code, and an intelligent examiner, and if the Patent Office is doing its job, should be able to point to these things and reject patents if they're obvious. That may be wishful thinking, and that is often much more difficult than it sounds. But I think applicants are going to have a more difficult time getting blockchain patents than perhaps in some other areas of technology. That said, there are, in my opinion, patentable applications of blockchain, and Walmart is a good example of a company that's using blockchain in a way that's not purely speculative. There's a good business reason to do so. Being able to track with a good sense where things are in the supply chain, being able to do recalls and instantly know by looking through a secure and accurate and verified ledger where items are. All of these things are really useful to a company like Walmart, which is effectively operations, is effectively that's really their strength, is being able to get products to the store no matter where it is. So I think there's a lot of room for improvement, and I think there are going to be some very contentious patent fights and licensing battles over technology that has been developed by one company or another.
Yeah, definitely. That's stay tuned to be sure. Matt, what do you think about lettuce on the blockchain?
I think that this is. I'm a total blockchain skeptic. So I think that this is crazy. The TechCrunch article says that they went from 7 days for reporting to 2.2 seconds, and it's as if blockchain was the only thing that could have done that. Any other ledger system where they were tracking, whether it's a SQL database or a non-SQL database, where they were tracking where the lettuce was going to and coming from, would have given them the same results. So, when you look at what is a blockchain fundamentally, it is a ledger system. So, from a patent perspective, if I have a device that tracks things throughout warehouses, I think that was one of the examples, that says that tracks it under a ledger system, just because blockchain is a different kind of ledger system. And I think that for most purposes, when you think about blockchain is sort of defined as a decentralized, well, Walmart doesn't need a decentralized system for tracking their lettuce or anything like that. Does a ledger, which they would have to track in a system, is that somehow fundamentally changed by using blockchain? My guess is that it's probably not. I think it's just a really good well-branded ledger system, and it provides some additional security, but from a fundamental basis of what it does for their business, I just don't see it. I think it's a great way to store value in currency, but that's because people believe it's a great way to store value in currency, and ultimately currency is always defined by what people believe there's value in. So yeah, I rolled the section on the massive savings for E. coli because of blockchain. It's just a good system implemented. That's what it is. It's a good tracking system.
I guess. Matt,
sorry.
Go ahead.
Oh, I was just going to say, just as a counterpoint to that. No, Denise, go ahead, please.
Nope, you first.
Okay. And as a counterpoint to that, lettuce is one thing, but there is a huge chain of suppliers that a head of lettuce will go through in order to be on shelves at Walmart. Even more so when you start thinking of giants like Nestle or where you may have multiple ingredients that are put into a product and tracking those. So, I mean, I agree with you about the fundamentals of blockchain. It's a ledger system. It is often overhyped for what it actually is. But in this case, having a public and a shared ledger between multiple companies, I think it actually does add a little bit of value here, especially in the processed foods or, in sections where there's a long chain of title between different non-Walmart related entities along the way. So all great criticism, and blockchain and Bitcoin is not the cure-all for everything, but there may actually be some interesting value adds here that just a simple SQL database isn't going to have.
Yeah, I was going to say the same thing, actually, that having some tool that is not proprietary to Walmart, but instead is, readily available to all of the people in the chain, not on the block. Never mind. that has value, and that also that there's an accountability, and it, particularly where we're talking about a health issue, like wanting, the food that is sold in your store to be up to health standards. That you'd want as many eyes on that issue as possible, and I think that blockchain helps facilitate that in ways that a standard and proprietary ledger might not. But I get what you're saying, Matt, and I knew that I teed up that question to you because I knew you would love the idea of lettuce on the blockchain.
For creating a non-sequential database or a sequential database, you can set the protocols so that other people have access to them and all of that. The question is Walmart going to cheat you and or cheat the public? And it seems like if their current system doesn't allow you to track the lettuce in 7 days, that anything would be better, right? Because then now you're actually putting in a system that's tracking. But so you in order to reach the conclusion that blockchain is fundamentally different, you'd have to say that a non-sequential database or a sequential database was not capable of handling the data set that it was tracking the lettuce. And so many of our applications, whether it's Facebook or whether it's all of these things which track massively more amounts of data than the ledgers, are not on blockchain. They're on non-sequential databases. Or like Amazon tracking or any of that is all done. But I'll stop my rant on the blockchain.
It's quite all right. Anybody concerned that Walmart appears to be determined to lock up as many blockchain patents as it can get? What do you think of that, Jordan?
Probably not a concern. I think a number of companies are probably looking to do this. Walmart in particular, actually in the past, I'd say 5 to 10 years, has really invested in research and development, which is, it sounds odd for a company that's a retailer, but they operationally have always been looking for gains, and they're actually one of the they file a significant number of patent applications. So. It's one of these things that the patent system allows for a competitive advantage in exchange for making that technology publicly available. So I don't think that it's going to give Walmart an edge that's going to close down all other retail superstores. But But maybe it will. I mean, maybe it'll be pennies. It'll save them pennies, but when it on the scale that Walmart is, that adds up to millions and maybe even billions of dollars.
Okay, Stefan, any thoughts on lettuce, blockchains, and Walmart?
Yeah, I took a look at one of the Walmart articles specifically linked to a patent application that is just published, so you can actually read the claims and see how the patent structure or the application is structured and what they're hoping to get. And I would encourage anybody who knows how to read a patent to take a look at it, because I think it sort of underscores Matt's point to some degree that if you read sort of the independent claims, they are quite broad. They don't actually use the word blockchain at all. And the sort of secret sauce that you would expect to be disclosed that would sort of count as the innovative step that would allow somebody to get a patent isn't actually there as far as I can see. So that, really what it boils down to is in this particular patent is having these two autonomous drones essentially exchanging identification information and only taking actions in response to having that identification information authenticated. That doesn't seem to me like it's particularly tied to the blockchain. You have to go all the way to dependent claim 6 before you start invoking blockchain keys. And so even the way the patent is structured acknowledges that the blockchain, which is so key to the story here, is actually only a small part of it, and they're in fact trying to claim much more broadly than that. And so it'll be interesting to see what the 101 issues are that come out of this, but it's also going to be interesting to see what the 112 sort of enablement and written description issues are going to be, because it would seem to me if companies are claiming the blockchain, with air quotes around it, without being specific as to which protocols or particular aspects of it they're claiming, they could run into some trouble on that 112 end. So I don't mean to disparage this particular patent. It seems like a well-written patent and all that. I just am pointing out that it's one thing to have a journalistic account describe this as a blockchain patent. It's another thing to actually read the thing and try to figure out what it's about. And I think I would encourage people to read it and see, what they think. It doesn't seem to me like it's too reliant on the secret sauce that everybody attributes to blockchain at this point.
Yes, thank you for letting us know that. Just because you call it blockchain doesn't make it a blockchain. All right, let us, speaking of drones, do one last story before we close out the show. So I've been looking for a good excuse to talk about the Preventing Emerging Threats Act, which is something attached to the FAA Reauthorization Act, which is pending in Congress now. And my excuse for talking about it, we could have done it last week when we had Nate Cardoso here from the EFF, because they are opposed to this act on a couple of fronts, separate fronts that we'll talk about here today. But we're doing it this week because Mattel actually makes things that fly. Victor in the studio was pointing out, he was all over the fact that Mattel makes the Jurassic Park toys, and one of them is a quadcopter pterodactyl thing. So your client and employer has a dog in this hunt, Jordan. What this act deals with, a couple of things that EFF is concerned with. One is they call it warrantless drone takedowns. It would give authority, and I think it would give it to, if I'm reading this correctly, the Department of Justice and the Department of Homeland Security to destroy, commandeer, and wiretap all unmanned aircraft regardless of size. Under certain circumstances that include when it's necessary to mitigate a credible threat posed by a drone to the safety or security of a covered facility or asset. So be careful where you're flying your pterodactyls, people, because there is this act pending where DOJ or DHS might be able to obliterate that thing under this pending legislation. The other thing that this, again, it's called the Preventing Emerging Threats Act. PETA, it's called, PETA. It also would give a congressional stamp of approval to biometrically screening U.S. citizens and domestic travelers. And I'm not sure what the point of access is, whether it would be, it's a travel related thing. I'm not sure if that just means it happens at airports. Oh, here we go. Before certain international flights. And the plan is to expand such screening to domestic airports. So we were talking about being biometrically, facially scanned at the mall. This would include facial recognition and various other biometric technologies related to travelers. So a couple of things to be concerned about in that bill. But, I really want my pterodactyl to have free reign as much as the FAA currently permits. What do you think, Jordan?
Yeah, and I want you and all the listeners to buy as many Mattel pterodactyls as possible. So I like my job. Let's keep it that way. This is interesting. I actually was thumbing through the text of the bill, and it's fascinating. It's a constitutional nightmare, I think, honestly. And there's some provisions in that bill. Let me see if I'll read it off, where it says that the secretary or the attorney general can't take the actions if or they have to avoid infringement of the privacy and civil liberties of the people of the United States and the freedom of the press, consistent with federal law and the Constitution, including with any testing and actually commandeering or destroying your drones or flying objects mid-flight. I could see why the EFF is taking a position on this, that this just can't go forward. I think there's too many things, even just going back to what is defined as an unmanned aircraft system. That definition has to be very tight. Otherwise, you're going to have, 6-ounce toys be considered in this, or you can even go to more extremes and say, baseballs or footballs, those are unmanned aerial systems. Is that going to be under is that going to be controlled under this bill? But I can see the security reason why the government would want to do this, especially around soft targets. Sure, the baseball stadiums, malls, places like that. But there's got to be a better way to do it than this.
The new shoeless Joe Jackson is DHS trying to rig the game by taking over the baseball and sending it over the back wall. Sorry, only I thought that was funny. Stefan, any thoughts?
I just keep thinking about the time I was on the San Juan Islands in this, quiet little hotel, and I almost said a bad word, was sitting outside my room playing with a drone, and it was buzzing as I was trying to sleep on this beautiful morning. And so if I had had a gun at that moment, I would have loved to have the legal authority to shoot it down. So constitutional privacy concerns be damned. That guy's drone should not have been waking me up, and I would have loved to shoot it out of the sky.
All right, on record as a a not early morning drone fan. Matt?
Yeah, I think that some of these you're balancing again the privacy and security, or in at least in the biometrics space of this, our FAA has significant controls in our airports, which are a priority in terms of security. And the question is biometric screening in these areas somehow a bridge too far from a privacy perspective? In terms of the drones, I don't know how often this is going to be misused. I would assume that there's a provision that your funds will be returned to purchase another Mattel drone when it's destroyed by law enforcement, and I guess I don't have too many concerns that this is going to be misused. I think that for home drone owners or recreational drone owners, I can't remember the term of art, but they have to they have to be certified now. I think that was the bigger provision of this, that you have to go through the certification in order to have a home or recreational drone, and that's a burden to the individual.
Yeah, definitely. All right. Well, I think it's about time to do our animal selfie of the week. I wish I had a Wi-Fi enabled cow for us to enjoy this week that had somehow photographed itself. But no, this is again from listener Alec, who emailed in about the biometrics at the mall issue, and also provided a link. He too, like we here at This Week in Law, are big fans of We Rate Dogs, which has not just a Twitter but an Instagram page. This is I don't know if they cross-post everything both places, but this is from the Instagram page. And We Rate Dogs is obviously lovely photos of dogs and occasionally a good dog selfie. And that's what we're treated with this time around. Somehow got the forward-facing camera on. Oliver did. The rating was, this is Oliver. He accidentally opened the front-facing camera. Can't get it to turn back around. 13 of 10. It's the same button, Oliver. Oliver's very cute and took this very nice selfie of himself. And thank you, Alec, for submitting that one for our pleasure and analysis. Our tip of the week relates to working at the NSA. I don't know if that applies to a lot of you, but if you work at anything like the NSA, taking your work home to try and get ahead and stay on top of your work, not a good idea. Gentleman working for the NSA started bringing home things. He had worked for the NSA's Tailored Access Operations, TAO, which is its hacking unit since April of 2006. He started bringing stuff home in 2010 and did so for about 5 years. And lo and behold, he's gotten about 5 years in prison, 5.5 years in prison for taking classified NSA materials home, even though he says, no, it was just to do extra work and get myself promoted. I think the NSA felt otherwise about it, and it's not looking kindly on that activity, and obviously not a good thing to do if you're working for the NSA. So that's our tip of the week. Our resources of the week are several. I'll start with the upcoming in October one in LA. We'll start here on the left coast. And it is the DMLA, which is the Digital Media Licensing Association, is going to have a conference here in LA on the 21st through 23rd of October. Just looks like a super interesting thing to attend if you are interested in digital media and its licensing. I did not even know this organization existed until now, but apparently it's in its 23rd year of doing this conference. And considering all things related to things like the blockchain. Will blockchain drive massive new efficiencies in your business systems and operations, or cut you out of the content distribution chain entirely? They're going to look at the hottest legal topics facing the media licensing industry, machine learning and AI. So really touching on some great stuff here. Google will be there to answer questions about Google image search. So that's coming up. Also coming up is me next week. I'm going to be moderating a symposium at Suffolk University Law School in Boston. We're doing an Internet of Things symposium there that I am moderating. There will be 3 different 80-minute panels with professors and judges and lawyers populating the panels on security and privacy, the Internet of Things and lawyering, and the Internet of Things and the bench. So if you're in Boston and interested in that, it's going to be next Thursday on 10/4. So if you want the details of that, head over to Suffolk Law's Office of Professional and Career Development. And that's where you can get more information about this symposium on the Internet of Things that I'm going to be moderating. And then our final resource of the week is an app for the folks in Buffalo, New York that was developed by Jordan and a colleague of his. This looks really cool. Tell us about the Good Neighbor app, Jordan.
Yeah, well, thanks. This is a neat project that Clark Dever, he's the other guy in that photo there, and the mayor, that we came up with that uses open data that the city of Buffalo has and puts it into an app. Many of you may not know, Buffalo has a really large immigrant and refugee population. The number of languages that are spoken in the city, are in the hundreds. So one thing that we thought that we could do was take this open data and then make it accessible in whatever language that Google can translate it in. So it's an app that we've been working on that allows you to do just that. Find your schools, your churches, your emergency services, get governmental information, regardless of who you are and what language you speak in the city of Buffalo.
That's really cool. And you got to actually hold one of those great big checks.
It's, I didn't get to keep it. Clark has it. So it's probably sitting somewhere in his house. Maybe he got it framed. But yeah, novelty checks are always great.
That's very cool. Well, congratulations to you and Clark, and wonderful work that you put that together. And wonderful work here today on the show. We're so glad you've been able to join us, Jordan.
Thank you. It's my pleasure. Really appreciate it.
We'd love to have you back sometime. We've had Jordan Walbesser here with us today as our guest, toy lawyer extraordinaire. Is there anything else besides the app that you'd like to plug before we go ahead and sign off for the day?
No, I don't think so. Just again, it's been a pleasure to meet all of you. I had an excellent conversation here today and group of panelists. So just hope that everyone enjoys the fall and closes out 2018 with a bang.
All right. And just beware of the pterodactyls. You never know where they're going to show up. Thank you so much for joining us today, Jordan.
Thank you. My pleasure.
Also, thank you so much to my two wonderful co-hosts, Matt Curtis and Stefan Spida. Stefan, what's going on in Seattle these days?
Rain, grunge music, Pearl
Coffee.
Jam. Yeah, coffee, Frasier. Every stereotype from the 90s is still just kind of going in a perpetual loop. Nothing's changed.
Love it.
Yeah.
Have to come visit. It's going to feel much more like fall there, I think, than it does in my neck of the woods.
Well, it's actually a gorgeous 75-degree sunny day today, and it feels nothing like Seattle in late September. So today would be the perfect day to be here, and you're not. So you missed your chance. Yeah. Sorry.
All right. Too bad. I'll try again sometime soon. Matt Curtis, back in the great state of, remind me, are you in Michigan?
Indiana.
Illinois? Indiana. There we go.
Correct.
Going back to Indiana.
Yep. Yeah. Still haven't played that song yet.
No.
But you'll get to see some great colors up in New England next week. That sounds great.
Yes, I hope to. Definitely. I'm flying in and out really quickly, but I'll be gazing out the plane window as I land in Boston, hoping to see a bit of fall color for sure. Tell us any updates about Pareto that you want to share with folks.
Just working away as is it's just the grind. But I want to thank Jordan for being on. And one of my favorite pubs is in Buffalo. So if you get a chance to go to Founding Fathers, have a drink for me.
I'll do that. Been there plenty of times.
Ooh, that sounds fun. Good trip up to Buffalo. I'm sure you guys are getting some fall colors and some fall weather.
It's actually pretty nice today too. I think we're also in the 70s. So not too bad at all, but fall's coming.
Very cool. Well, we hope that you all enjoy your fall season. We thank you so much for joining us for this episode of This Week in Law. It's been a great discussion. I'm so glad that if you've been able to join us live, that you've played along with us as we recorded the show at 11 o'clock Pacific time, 1800 UTC here on Friday, September 28th. We record the show every Friday at those times. So if you like to join us live and jump into IRC, we love jumping in there with you and interacting with folks during the show. There's been some good cow humor in there today, among other things. But don't worry, if you can't join us live, you can always enjoy the show on your own schedule and on whatever device you please. If you go over to twit.tv/TWiL, there is all kinds of information about that. This show will be up there just as soon as it is edited and posted. And all the rest of our shows going back until really the Jurassic period when pterodactyls flew the skies are there right there on the show site for you. So do check that out. Whether you're a video person or an audio person, we make it available in all those formats, whether you're a YouTube person or an iTunes person or a Stitcher person, or however you enjoy the show. All the information about doing so is right there. So we're just thrilled that you join us. We're thrilled that you reach out to us between the shows and give us great ideas for things to talk about. I'm Denise at twit.tv. Please, if you'd like to get in touch with Stefan, send him emails via my email too. Or you can reach out to Matt. He's Matt C at twit.tv. We're still trying to figure out why Stefan can't get our email. This may be just an ongoing thing. That and Bolshevik references we plan to maintain for as long as possible.
It could be related.
They could very well be related. What else?
Controlling all aspects of Stefan's life. We're trying to take his advice that the Bolsheviks should have went further.
That's right. His email is being thwarted from a totalitarian regime.
Not quite advice.
So if the email thing just seems way too complicated, reach out to us on Twitter. We're all there. D. Howell is me. Stefan Schweida is Stefan. And Lawpint is Matt. That would be a great way to just let us know what you have stumbled across in your journeyings through that platform. Or we're on, the show has a page on Facebook as well, and still one on Google+. And I get notifications from both those platforms. So, feel free. Reach out to us there as well. And just let us know what you thought about what was going through your head as you tuned into our discussion. We'd love to hear your feedback, your insights, your suggestions as to things we should talk about in the future, things that you've seen that maybe we didn't see because they're a little bit obscure and not just blasted all over the headlines everywhere, but super interesting for our area of discussion. What else? We'd love to hear from you about people that you think we should invite on the show. I am not shy at all about inviting people on the show, and I am not sensitive about being told no. We invited Senator Mark Warner to come on the show, for example, because why not? You don't know unless you ask. He said no, but we're going to keep trying. It would be fun to get him or other of our elected representatives on the show. So if you have a particular one that you'd like us to reach out to, give me a shout. I might just do it. Until next time, though, we hope that you take care. Enjoy your fall as we turn over into October here very shortly. And we'll see you next week on This Week in Law.